Hello, I'm Waqar Rizvi, and this is Scope. In the first segment of today's show, we're going to be discussing a U.S. federal appeals court which has ruled for the first time that prisoners at Guantanamo Bay, Cuba, are not, in fact, entitled to due process. Now, of course, in a few moments, we'll discuss exactly what due process means in this context. Nevertheless, it's important, isn't it? Because Guantanamo Bay has been an issue which has now been fairly long-standing, and the detainees there, as well as their rights, have been under debate for a while now, considering Guantanamo is technically not, of course, the U.S. mainland. So the debate has always been about which laws do and do not apply to those detainees. Now, of course, the alleged crimes, or the crimes that these detainees are alleged to have committed, are certainly very serious, but not all of them have been proven in court at this point in time. So can the United States indefinitely hold these people, as well as not give them the rights that they probably should be given, according to at least their defense lawyers and others at this time, or is even so far, as they should have gotten for these many years that they have been detained at this time? Let's discuss all of that a bit further. We're joined by Michel, who is a human rights lawyer. He teaches at Columbia Law School and is most recently the author of the bestseller Last Mission to Tokyo, which is about war crimes trials in the Pacific after World War II. He's joining us this morning from New York. Michel, thank you for your time this morning. If you can just put this into context for our international viewers, in your opinion, what does due process specifically mean? Are we talking about the kind of, rules and regulations that you would have upon normal U.S. citizens versus then what these detainees at Guantanamo have access to?
That's exactly right. The due process clause, why it matters that the court held that the due process clause does not apply, is whether or not the detainees are subject to the fundamental human rights document of the United States, which is the U.S. Constitution. By holding that the due process clause specifically does not apply, the court the majority of the court was essentially holding that no constitutional protections extend to the detainees. Anything that Congress and the president deem fit for the detainees is good enough. And that's the ultimate significance of the due process clause. It sounds like a very technical provision of the Constitution, due process. But what it really is it's the basic protection of human dignity in the United States Constitution, so that no one can be deprived of their life, liberty, or property except upon procedures that are deemed fair and trustworthy to a constitutional standard. And that is ultimately what the court held the detainees in Guantanamo are not entitled to. For the first time since Guantanamo has been open, the court reached this conclusion.
And that's concerning because I would think at some level that the argument is that because they are in Guantanamo, not in U.S. mainland, that the court would rule this way?
That was right. It was a very technical, a very cramped view of the Constitution's application, so that the court held that Guantanamo is essentially, again, the kind of legal black hole that it was initially designed to be. Now, as someone who has followed these issues for a number of years, I thought these issues had been resolved, particularly when the Supreme Court held in 2008 that detainees are, in fact, entitled to some constitutional protections, particularly something that's very closely aligned with the concept of due process in American law, which is the right to habeas corpus. That's an old doctrine that comes from English law that says you always have the right to be able to go to a court to say that I am being held unlawfully. And what's so troubling about the decision from the court today, or from the court last week, is that they're holding, yes, you can come to court, but you really have no rights that you can assert in court. It's essentially a hollow, meaningless exercise that you can come to court. You have the constitutional right to come to court, but once you come to court, you have no rights that the government is bound to respect. It's a very troubling lurch. I think it is likely to be reviewed by the entire court. So this particular decision was handed down by what's called a panel of the D.C. Circuit Court of Appeals. It's the court underneath the Supreme Court in the United States, where a number of Supreme Court justices ultimately come from. Brett Kavanaugh most recently came from the D.C. Circuit. And they ordinarily decide cases, much like they do in Pakistan or the United Kingdom or any other common law system, in panels. So there'll be 3 judges who decide a case in the first instance. And in a case of an extraordinary importance, and I would say this is certainly one, the whole court, which is currently composed of anywhere from 9 to 11 members, depending on whether or not there are any judicial recusals, can actually take up the case again and decide with definitive clarity whether or not the detainees are entitled to due process. And depending on how that full court ultimately decides the issue, the U.S. Supreme Court, I would say, is probably likely to take this issue up. This is a very significant thing for a U.S. court, even if only a panel of the D.C. Circuit Court of Appeals, to hold that there are literally people in the United States, in the territory of the United States, which is what Guantanamo is, who are not, as a legal matter, people. Because that's ultimately what the Due Process Clause protects. It's an entitlement to the protections of human rights for people. That's what the Constitution says. And so it's a really troubling ruling and a real break.
Just as a final comment before Michel, about this issue of, the political will, right? Because, the politics is important here also, right? On the optics side, we have these men who have been alleged to have committed horrible crimes, a lot of them. Again, not proven necessarily in a court of law, and of course that has its own challenges, certainly for both defense and prosecution, certainly, and I don't want to play that down. But do you think that the politics sort of blocks the willingness of any sitting administration to actually do the right thing? Because we've been talking about Guantanamo and what to do with it for so many years now. Even during the Obama years, there was talk about shutting it down. That never really occurred, and I imagine it came back to just political courage, doesn't it?
It does. It really does come to political courage. On the very first day in office, President Barack Obama signed an executive order to close Guantanamo, to clean this mess up, and due to basically the politics, a lack of political will to solve the problem. It wasn't solved. Now, he reduced the detainee population significantly from about 250 to about 40 men, which is what it is today. And I think that's actually in some ways made the politics harder because it's fewer it's fewer individuals involved. But I would push back a little bit on the idea that all of the men in Guantanamo have been accused or are believed to be guilty of serious crimes. There are a number of individuals in Guantanamo who the Obama administration, and not just the Department of Defense in the Obama administration, decided should be released. There are a number of those individuals, but they couldn't be released prior to the Trump administration taking office. So there are people that even the United States has said for going on a decade shouldn't be there, still being held there. And so for the U.S. courts today to say those people who even the United States doesn't think should be in Guantanamo, they have no rights. They are not people under the Constitution. It's a really troubling holding, and I hope the full court takes up the case.
Indeed, and we'll keep a very close eye on that, but we appreciate your time this morning, Michel, for putting this into context for us, explaining this for us and our viewers as well. This issue of due process, viewers, is an important one because, as Michel there mentioned, it's basically we're just talking about basic rights that any human being should really have in front of the law. In this case, of course, the U.S. law and U.S. courts. And this issue of Guantanamo, as I put to Michel as well, is it's hard to separate the politics from this and the optics from this as well, right? Because these men have been sold to the public as these horrible human beings, and they may very well, some of them be, but that needs to be proven in a court of law. You can't just have allegations thrown out there without proper process to prove those said allegations on the part of the prosecution, and then to have fair defense or fair access to defense. That's just how our world should work if we are, of course, completely fair and just, even towards the worst of people who may have committed the worst of crimes also. I'll be back with the next segment after this break. Welcome back, viewers. You're still here in Scope with me, Waqar Rizvi. Now, in this segment, we're going to discuss news about the Gambia's legal bid to hold Myanmar accountable at the ICJ, which is the International Court of Justice, about their case of genocide against the Rohingya minority there in Myanmar, who has, of course, a lot of them have had to flee the country because of the Myanmarese military's actions towards them, as well as, essentially the razing to the ground of their villages in Rakhine State and in other parts, of course, of the country also. Now, Canada and the Netherlands have said, and there will be discussion about this word join, the Gambia's legal bid to hold Myanmar accountable. Now, one of our guests who is joining us, in fact, has said that it's not actually them joining, but they will now intervene and assist the Gambia in the case, but they're not actually formally joining them, as that is the Gambia as a party in this case from the side of the prosecution. So what exactly does this mean? This play of words, and of course, is a lot of legal jargon, which we're going to need to try to understand specifically what that means. Nevertheless, this does add pressure, public pressure, because the optics are important as well here, right? Where you have Canada, the Netherlands, at least standing by the Gambia, in this case, against Myanmar, asking for accountability for the Rohingya peoples. Will other countries do the same and hopefully properly join this legal case at the ICJ as well? Let's discuss all of that a bit further. We're now joined by Professor John Packer, who is a Neuberger Jessen Professor of International Conflict Resolution. He's also the Director of the Human Rights Research and Education Center at the University of Ottawa. He's joining us this morning from Ottawa. Also joining us this morning from Ottawa is Farid Khan, who is the Director of Advocacy and Media Relations at the Rohingya Human Rights Network. And finally, joining us from London is Shahida Tulaganova, who is an Emmy-nominated, award-winning producer and director who has just completed her latest documentary feature film called Exiled, which is about the genocide of Rohingya Muslims in Burma. Shahida, Farid, and John, thank you to all three of you for your time today. Now, John, I know that it was you who gave us that clarification about what this word join means, as was presented in many of these articles and reports about what Canada and the Netherlands are doing vis-a-vis this legal bit of the Gambia to hold Myanmar accountable at the ICJ. Could you just, in layman's terms, clarify for us what exactly the Canadians and the Dutch are doing?
Well, I think that it's quite clear from the public statement and the fact that they've made a public statement that they are, first of all, conveying the idea that they will stand with Gambia. And in this case, they are obviously taking the side that they believe that there has been a genocide. And they're going to make available some of their resources, particularly legal lawyers and others who can assist the Gambia. But you really have to read carefully the statement. The statement itself is unusual to issue a statement basically about an intention to do something, not actually doing it. So the purpose is clearly a public relations purpose. And what they're saying is that they believe the case needs some support. They're responding to a request from the Gambia that was issued a year ago at the United Nations by the Vice President of Gambia, which called upon other states to assist. And so this is their response. And they've done it under some pressure, I must admit, from particularly from their domestic constituents, meaning Canadians and Dutch citizens. Now, what they've actually said is that they will intervene. And that's an important word because under the statute of the International Court of Justice, there are different ways in which these countries could participate. And intervening does not mean become a party to the case. And the intervention would be either by request or on their right to comment on the specific case and specifically the Genocide Convention itself, what it means.
Shahida, what are your thoughts on this? I imagine that from the Myanmar's government's point of view, from Myanmar's government's point of view and Aung San Suu Kyi's point of view, etc., this just adds more pressure upon them to do the right thing, doesn't it?
Well, theoretically, yes, but so far the Burmese government wasn't that responsive to the international pressure. I mean, we saw how Aung San Suu Kyi and her team behaving in the hearings on International Court of Justice, and it was absolutely despicable. And they carry on trying to portray to the world that they're doing something about the Rohingya, whereas they don't. I do not think that I think Myanmar is, and Aung San Suu Kyi in particular, is very busy with forthcoming elections. And that's what her main priority. And therefore, I don't think they're going to be so not even sympathetic, but responsive to the pressure which is keeping up on them.
Farid, what are your thoughts on this? I know that you've also posted on social media about this, and of course you work very closely with issues related to Rohingya, as well as what's happened to them. Do you think that this is an important step forward, even if it is just symbolic at this time?
Actually, yes, it is important because it shows well, first of all, it adds two more voices to the case, even though it's at an intervener level. It is significant because it adds two more voices. It brings resources, legal resources to bear in support of the Gambia case. Canada can make its case, on those particular issues of interest. And the Global Affairs announcement, which announced that Canada and the Netherlands were intervening, stated that they are particularly going to talk about issues of sexual violence and gang rape as part of what they are going to intervene on. And having additional voices, particularly voices in the West, join Gambia shows that it's just not one nation. There are other nations as well. And it's my understanding that there are efforts underway in Europe as well to try and see if maybe the UK and maybe some other nations could add their voices in support of the case as well.
So, John, what do you think is holding the Canadians and the Dutch back? I mean, you can obviously probably comment more easily on the Canadians, but what's holding them back from properly just joining this case? I mean, if you've taken this much of a step, even if it is in response to the Gambia's request, why not just go the whole way?
Well, that's an excellent question. And really, if one scrutinizes this, it doesn't really make a lot of sense because in political terms, they've taken a side. And they're making it very public. They've issued a public statement about the side they're on. But on the one hand, they haven't taken the kind of step of pressure. You mentioned pressure. For example, the German government, which has not made such a statement, but has suspended its aid to Myanmar as a result of this case, and specifically its concerns about compliance with provisional measures. Canada and the Netherlands haven't done that. Instead, they've issued a public statement, and really they're taking the kind of least step that they could under the statute, which is to give kind of technical legal assistance to the Gambia. What's holding them back? I think they're really, like many countries, trying to play a bit of a double game here. They are interested in supporting Myanmar's transition to democracy, which most observers think is really not going anywhere. There's an election to take place shortly in the Netherlands this autumn, and we'll see. But it really, the peace process and the transition haven't been going well. And from the perspective of the Rohingya, it's been a disaster. There's been nothing getting improved. In fact, things appear to be getting worse. So I'm really not sure what the answer is, why Canada and the Netherlands would now not fully join, and from a legal perspective, take responsibility as a state, as a party, to really carry this forward.
Shahida, please do let me know about what your thoughts are about, at this point in time, why these Western governments and many of these governments that have at one point in time spoken very highly of Aung San Suu Kyi, why they are not being stronger when it comes to this case. Do you think they're still holding out hope towards democratic transition, and that's why they don't want to be seen as too critical at this time?
I think this is partly the case, yes. Unfortunately, in a lot of European countries, the leadership is still pretty much the same. People who take key decisions still remember the times when Aung San Suu Kyi was this person house arrest, and it was the symbol of democracy and hope for her country. She's very well spoken. She does appeal to the Western leaders because she speaks perfect English. She knows how to behave, and she has this persona of a very fragile woman who is trying to fix her nation, which is not the case. And I agree with Professor Parker that democratization process doesn't really go anywhere in Myanmar. In fact, it goes backwards. And unfortunately, the leaders in Europe in particular didn't receive this wake-up call that whatever you're doing is in trying not to confront Aung San Suu Kyi and the Myanmar government directly and very strongly about not only the Rohingya issue, but the issue of lack of democratic reforms and economic reforms in the country. It's not working. You cannot really dance and pretend that something is not happening. It is happening. Burmese military has always been strong in the country and still hold on the key segments of the economy. And unfortunately, it looked to me like Aung San Suu Kyi is just the front man for them. She's not really a key decision maker. In fact, it does seem, especially her response to the Rohingya crisis and her attitude to them, not intention, but she never called them the Rohingya. She calls them just Muslims. And the denial of that shows that she is not willing to move forward. And she's willing to side with the military just to stay in power.
Yeah. All right, Farid, I'll give you the final word before I let the three of you go. Tell us about, what you have heard sitting there in Ottawa. The seat of government is right there. What are the Canadians saying? Have you had communication with officials there about if this will strongly be taken forward on the part of Canada vis-a-vis this case at the ICJ?
Well, we've been calling on Canada to intervene in this, not just intervene, but since September 2017, when the atrocities first came to light, we've been calling on the Canadian government to actually file a case under the Genocide Convention at the ICJ. This announcement is the first bit of positive news that we've had since September 2018, when two unanimous parliamentary motions were passed recognizing the genocide. Canada became the first country to recognize the genocide. This announcement only happened a few days ago, and unfortunately, we have not had any direct contact with either global affairs officials in Canada or any of the other people around the minister or the government who are directly dealing with this. It's our hope that this is going to be a major action. It's certainly unprecedented because Canada has not participated in any such case in recent memory. And the fact that they have made this decision to do this with the Netherlands says that they are, trying to live up to their claim that they are a defender of the international legal order, which is under assault on many levels around the world. So we're still waiting for additional news from the Canadian government. The details that we have are what was in the announcement, and we're waiting to see what happens when Parliament resumes, because I'm assuming at that point the opposition parties will be asking questions around this issue when the government, after the government issues its throne speech.
Indeed. Well, we'll all keep a very close eye on all these developments as well going forward, because this is an extremely important case. But we appreciate John and Farid for their time this morning, as well as Shahida for her time speaking to us there from London, and for the context and expertise that they'll shared with us vis-a-vis their knowledge of this case at the ICJ, as well as now the Canadian and Dutch involvement possibly in that case against Myanmar, to hold it accountable regarding what it has done towards the Rohingya who have had to flee, as well as those who are now stuck in the country as well, but are now out of their homes and are essentially IDPs within their own country. One hopes that these countries can actually grow the courage and have the courage to actually do the right thing and actually join this case, so that there is proper accountability in this regard in front of a proper court. I mean, of course, with evidence and all of the above, we need to have a fair process, certainly, but we need to have, a process that everyone actually cares about. We can't just allow for this to fester with hopes that, there may be a democratic transition at some point, as our guest there alluded to. That might be the case, and as to why these countries are not joining this case properly, legally, on the side of the Gambia. How much can the Gambia do alone in this case? I mean, it's of course worth applauding it for doing this, but it certainly needs the support of the rest of the international community as well. I'll be back with the next segment after this break. Welcome back, viewers. You're still here in Scope with me, Waqar Rizvi. Now, in this final segment of today's show, we're going to discuss recently redacted documents which have shown that the UK has, for quite a number of years now, ever since the war on terror has begun, has offered immunity, full immunity, extended immunity to around 200 U.S. civilian as well as technical staff who are based on a UK military base, and they've been involved, as I said, in the war on terror. What does this mean? Why have they been given this sort of immunity? It raises several questions. Does this mean that they're doing something which would be seen normally as against UK law? Have they been involved in, for example, rendition flights, torture even, as we know the US was using as a method to try to extract information from alleged terror suspects? We know that that has happened, for example, at Guantanamo, as well as black sites that the CIA has run around the world as well. Are these one of those sites as well, possibly, at this base, or is the UK simply trying to cover up its tracks of its involvement in this entire process? Also, let's discuss all of that a bit further. And I'm joined by Peter Finn, who is a senior lecturer at the Department of Politics, International Relations and Human Rights at Kingston University, London. He's joining us now from the British capital. Peter, thank you for your time today. How worrying is this sort of revelation, right? Because, I mean, in the context of things, 200 civilian and technical staff is a fairly large number to have immunity extended over and over again too.
Yeah, so, I mean, to be honest, it raises more questions than it answers. Exactly. Why did 200 people have this immunity? What exactly was it that they were doing that would need this immunity inferred on them? Why did the British state grant it for so long? Why was it renewed? Without further details, it's really hard to comment on the specifics, but I just pick you up on one point there. I would, we should stick to what we do know, and so far as I'm aware, there's no evidence that there was a black site in the UK. So I would be really careful in making any kind of...
No, of course. I was completely, hypothetically stating something, but I totally get what you mean, to be careful about the details. But I mean, as you said, a lot more questions than answers at this point in time. But nevertheless, I mean, at the least, it seems like, and again, you can correct me if I'm wrong, it seems like this may have been covering up for something. I mean, this possibly means that something untoward may have been happening, which would have been against UK law at the very least.
So that might be the case. I guess it's for the UK government to refute this and to not do things like stand behind the NCND policy, which essentially means the UK government doesn't comment on special forces operations and intelligence operations. It might mean that, but we honestly don't know. This is an example of probably quite awkward information coming out for both countries in a very surreptitious manner. I mean, the way this came into the public domain wouldn't really have been predicted by anyone. I mean, it's very tragic the way in which it's come into the public domain, and it really does just raise lots of questions. I mean, MPs have raised some of these questions. David Davis, for instance, a Conservative MP of a many decades standing, has raised similar questions to the ones we're talking about now. Government organisations like Reprieve that are involved in investigating and representing those who have been subject to rendition operations have raised similar questions. I think what it does do is probably strengthens the case for a judge-led inquiry into what the UK's role really was in rendition operations. Yeah. There's been some great work done by parliamentarians, in particular the Intelligence Select Committee and the All-Party Parliamentary Group on Drones. And they have, over kind of the last 15 years, collectively done some fantastic work, and as well as work by academics and other groups like Reprieve. But there needs to be a full judge-led inquiry to investigate exactly what happened.
In your opinion so far, and again, obviously there's not a lot of information about this and no proof in front of a court of law, because I know that even the UK has, much like the US, also not been very reticent to international investigations into its forces' role, be it in Iraq, Afghanistan, or elsewhere around the world, and if not they've been involved in war crimes or any human rights abuses. But so far, within the war on terror context, do you think that there possibly have been crimes committed of some sort, and that does need to be then dealt with possibly at an international level if the UK government isn't willing to do it itself?
Well, so, I mean, it's a matter of record, both kind of the historic record and legal findings, both in the US and the UK, right? That UK forces and personnel, both military and intelligence, have been involved in crimes against detainees during the war on terror. I mean, on the US side, most obviously there's the Abu Ghraib scandal, right? And then all of the events tied to Guantanamo. On the UK side, there was the tragic death of Baha Musa in Iraq, and then there has been evidence of kind of both parties working together to facilitate each other's operations. So these have happened, and there have been investigations, right? So it's not that the UK state and the US state have been completely deficient in this regard. Both have had investigations, but they don't. Especially we're here to talk about the UK. The UK side, there's clearly more to investigate. There's clearly more to do in terms of connecting the dots as to what actually happened with relation to this. So that's why I would call for a judge-led inquiry.
Okay, another Voices conversation. We're now joined by Harry Fear, who is a journalist and filmmaker. He's usually based in Oxford, the UK, but he's joining us currently from Aix-en-Provence in France. Harry, thank you for your time and for joining us today here in Scope. What are your thoughts about this report about, the sort of immunity being extended to all these civilian and technical staff, US staff, that is, at this UK base? Do you think something is being covered up for because of these extended immunity?
I think what's being covered up, in a sense, is the fact that the UK is more of a client state for US empire than we normally think. I think that we're seeing, because of the tragic death of Harry Dunn on the part of Ansa Koulas, we're seeing, in a sense, the fate of US empire and its mammoth footprint playing out with these kind of fringe tragedies leading to the highlighting of the world as it really works in terms of the US empire, and even rich developed nations like the UK's really being a client state for the US in terms of its continually expanding global surveillance, including of European allies. So what I see here is, in a sense, with the story of the campaign of immunity for US personnel, I see here the dirty secrets of the British state assisting the US state in private to spy on the world and do its best to influence and control the world for US national security and national interests.
That's interesting. And Peter, I wonder if you agree with that, because it does seem like, I don't know if you agree with the client state or not, but there are a lot of people who do say that, right? That the UK is almost a client state of the US, and it has been, especially when it comes to the war on terror, and especially during the era of Tony Blair, et cetera. What are your thoughts on that? And does this raise questions in that regard as well?
So the UK and the US have worked closely together for decades, right? In many different ways. What I would say is that the UK is a democracy, right? We have parliamentarians who are investigate this stuff. We've had lawyers who have helped engage in legal processes that have uncovered some of this. There are ways in which oversight takes place in the UK, and this is another example of evidence feeding into these discussions coming out in a surreptitious way. So the UK, for instance, was demonstrated to have been involved in renditions to Libya as a result of documents that were found at the fall of the Libyan state in 2011. And no one in the UK state would have predicted that would happen. This is another example, as Alan said, the tragic death of Harry Dunn has led to the release of this information. No one would have predicted that would happen. But now it's up to the UK state to live up to the values which it says it does, right? If you go on the UK government's websites, they talk about the importance of human rights, they talk about the importance of democracy, they talk about oversight. So let's see this oversight in action.
Oversight, that's important, right, to see, Harry, because now that this is out there for all of us to see, and hopefully for Britons to follow up on as well, will there be accountability in this regard? Will there be more transparency? I would think that the argument on the other side will always be, when it comes to the war on terror, things happen that may not always be within the laws of any respective country, but are done to keep, a respective homeland safe, be it the US and the UK. Those are long-standing arguments in that regard.
I think the key concept here is that the US concept of homeland is the world. And under Trump, we're even seeing the US concept of full spectrum dominance expanding to space for the first time. This is the actual world as it really works in practice. And, the Edward Snowden revelations showed the global surveillance that hasn't been stopped, that is continuing to be expanded, and that's part of the US's sort of security and intelligence footprint. And at the same time, those who actually do expose the war crimes, for instance, Julian Assange, he's now being treated like a terrorist suspect locked up in the UK's Guantanamo Bay, awaiting extradition to the US. So the concept here that there are healthy processes of oversight in the UK democracy it's not really easy to argue that, I would say. Of course, there are domestically in Britain, we have political figures, even on the conservative flank, who are outraged by the treatment of Anne Sekoulas, also with the treatment of Julian Assange. But this hasn't actually penetrated the wider social conscience or British Westminster politics. And I think that's the key here.
You know, I just can't get over the feeling that when you're extending immunity to so many people, it almost by definition feels like you're hiding something, right? And we know that immunity has been a controversial issue for U.S. personnel around the world. So we're not just looking at the UK at the moment. I mean, I'm going to bring in Japan and Okinawa, and we've had issues there as well with U.S. personnel and how they've acted there. You know, being drunken outside the base, you know, raping women, et cetera. And again, those are, you know, bad apples, and I'm not going to generalize all U.S. personnel with that. But nevertheless, when you extend immunity continually and you haven't really done the kind of public discussion about this sort of thing, it just feels really suspicious, doesn't it?
I mean, yeah, and so it's up to the UK state to demonstrate with a full kind of public investigation of these events as to why their immunity was granted. It might be that they're hiding something. It might not, right? I mean, these agreements, last for decades. The US and the UK were both involved and continue to be involved in some pretty questionable practices, not just with relation to detainees, but with relation to drone strikes, for instance. So there's no, like, they might be hiding something here, but I'm certainly not going to speculate as to what that might be. That's for them to answer. I think just to kind of go back, I think you raised the idea of utilitarianism, right? Like, basically the ends of these renditions justify the means. Well, I mean, that argument is wholly flawed. The ends, like torture, doesn't justify. The ends of torture don't justify the means. In fact, the stronger utilitarian arguments would suggest that actually, when you torture someone, you're more likely to get false information. So I would just sort of, you need to be careful, right? Giving any credence to that argument.
Yeah. No, I completely agree with that. Harry, let me give you the final word before I let both of you go. On this issue then of accountability, right? And we've seen these sorts of cases happening a lot. We've just also had, we still have Guantanamo that is open. Also, there's so many issues when it comes to the war on terror and questions of human rights abuses connected to the war on terror that still very much exists today. It feels like we've all, as in the rest of us around the world, have almost moved on from that. And we're sort of, allowing whoever performed these crimes to get away with it. Is that your feeling as well? Do you think that they will get away with it? Or do you think that we will have some sort of an international tribunal, et cetera, set up at some point to deal with this?
I think it's more likely Trump would bomb The Hague than we'll see justice at the International Criminal Court related to US officers and the war on terror, quite honestly. I think that, though, in the UK context, we do have this important story with Anne Sekoulas and the, in a sense, prosecution in absentia. I think that is definitely something to keep our eye on, because there is a valid and ongoing process of justice with regard to the death of Harry Dunn. And it's because of that we're seeing these these leakages of information related to the immunity campaign. So I think that could actually lead to even further revelations that inadvertently reveal the extent of the US empire, in a sense.
All right, we'll leave there as a final. We appreciate both Peter and Harry for their time and, of course, for contextualizing this argument for us. As Peter there correctly, of course, pointed out, I just put some arguments forth just for the sake of argument's sake, because there is a lot of defense presented when it comes to these sorts of actions about the need to secure homelands, the need to have, secrecy around these sorts of operations because the public may not completely understand, because certain things need to be done that will not always be according to UK, US, U.S. Or other Western countries' laws when it comes to the war on terror, and that should be okay in our minds because it is meant to keep us all safe. But then we're meant to be putting a lot of trust in these respective governments to do the right thing at any given point in time, which again is very hard to do considering the track record that we've seen in the past. Nevertheless, as Peter said as well, the UK says it's a democracy. So should it then, and shouldn't it then, in fact, be conducting a very open investigation into why this sort of immunity exists for all these personnel and has continually been extended without any really public reasons, at least given, to justify that at this time. Can we trust at all times that our governments will do the right thing when it comes to the war on terror, especially the Western governments that have been so heavily involved in, again, as I said, trying to secure all of us from the big bad wolf terrorists as we speak of? That's all from me for the moment. I have been Waqar Rizvi. Thanks for watching.